Hello.
Yeah. A very good afternoon to everyone present here. I am Riti Jindal, the student coordinator at LawInternships and the moderator for today's interactive session organized by LawInternships. LawInternships provides internship opportunities in the field of law, primarily to the students pursuing undergraduate or postgraduate programs. Advocate Amrita Jain, partner at LawInternships, along with her team of young, dynamic, and competent members, assist in providing opportunities for gaining professional experience as well as improving legal skills while being enrolled in a full-time law program. The objective is to prepare students for the real world by imparting practical exposure and relevant skills through legal internships. We have amongst us Advocate Vaibhav Mishra, sir. Sir is an advocate practicing in Supreme Court of India, Delhi High Court, and Delhi District Courts. He currently works as a senior associate at C&C Associates, Advocates and Solicitors, and appear and argue across all courts and forums. Sir has reported 10 judgments. He has also authored a book on Patna High Court titled The Illuminating Heritage of Patna High Court and a brief view of some selected judgments, which was published by Navchargan Prakashan and is forwarded by HMJ Shivakirti Singh, Chairperson TDSAT. He also has written an article titled Jurisprudential and Legislative Views on Information and Data Policy in India, which has been published in Volume 1, Issue 2 of the Quarterly Bar Review issued by Delhi High Court Bar Association. We welcome you, sir.
Thank you.
Also, I would like to mention it to the participants that the competition of the National Judgment Writing Competition, the proposition has been drafted by Sir. So the session will start by the first 15 minutes. Sir will discuss about the proposition, and the next 15 minutes floor will be open for the participants' queries and some of the clarifications which we received via mail. So without delaying any further, let's begin the session for today. Over to you, sir.
Thank you, Riddhi. I'm using my mobile, so in case my audio goes down or there's a lack of communication from my side, just let me know, ma'am.
All right.
Thank you to Law Internship and to the various people behind this platform. And I've gone through this organization's background profile. I believe they're doing an outstanding job in giving opportunities and various legal platforms to young law students and even beyond them to young legal professionals. So my best wishes to them, and thank you all for giving me this chance. As Riddhi said, we'll be speaking on the first 15 minutes on the proposition for judgment writing competition, which has already been given out to various participants. In this 15 minutes, I will just discuss the small part of the problem, and then I'll just give a hints as to how someone should write a judgment if a proposition comes across that person. And I'll give an insight from a lawyer's perspective, although I'm not a judge, neither have I sat for as a judge anyway, but I can give a an insight into judge's mind, since I worked as a law clerk also in my initial days after passing out with judge in Honorable Supreme Court. So I'll give both the sides, so that I hope can help the participants in giving the answers to the judgment writing proposition. Uh, I'll start with the proposition itself. As the participant must have gone through the same by now, it just revolves about a landlord-tenant relationship. If I can just give a brief preview of the problem, the tenant had agreement to sell with the erstwhile landlord, the landlady in fact, and she unfortunately passed away before it could be finally, if I can use the word finally, executed, and a specific performance could have been done. Now, this tenant used to pay the rent also to the landlady, but sometimes the landlady would not accept the rent, and so as to create a ground for termination of the lease deed itself. But after some time, the landlady accepted starting rents again from this tenant. And in the meantime, before this landlady passed away, there was an agreement to sell formed between the tenant and the landlady. Now, what happened is that the tenant says from his point of view is that this was signed by the landlady and a proper deed was there with two witnesses also who were there and who were witnessing it when this agreement was formed and signed by both the parties. There was a problem of mutation also, whether this conveyance deed had been mutated or not, and whether it had been done. But the tenant was not informed about it accordingly by the landlady. Unfortunately, when the landlady passed away, then a son of the landlady or the daughter of the landlady came into the picture, and he or she disputed the whole agreement to sell, and that is where the problem arises, because now the tenant wants an specific performance of the agreement to sell, which he had or she had formed with the erstwhile landlady, because now the son or the daughter of the landlady dispute everything and they want the tenant to be evicted. So this is a brief part of this complex problem. This is actually a real life scenario on which I've been working. So I've just given a small part even in this problem. This is much more highly complicated when it's in court. We've given a very miniature view of this for the participant because as a young professional or as a young law student, we don't want them to be confused with the highly technical stuff which this problem gets involved in. When you see such a problem, there are a couple of things which you should keep in mind in writing a judgment for the same. Of course, you should follow the rules and regulations of the competition which are there regarding the drafting and formatting and how do you finalize that and what citation style you should follow. I'm sure the in the rules and regulations of the competition that must have been spelled out accordingly to the participants. Apart from that, you should try to read this problem again and again at least 10 to 20 times so that you get a brief preview of how this is panning out. The more you read, the more you get to know more things about this particular problem from different aspects of it. When was this lease deed? Whether this lease deed was terminated? This agreement to sell, was there one? Was there two? Was there three? Who were the witnesses? If there was more than one agreement to sell, were the witnesses changed in the second agreement? In the addendum also, what was the change in the language, if there was any? Uh, I'm sure I'm not giving any hints for the participants with the host that I'm just spelling it out because it becomes easy for them to understand and give their answers. So you should read this again and again, and then you'll different answers will crop up in your mind the more you read it. And this will particularly help once you become a lawyer also, especially if you want to go to litigation. Even if you want to become a corporate lawyer, the more you read an agreements and drafts of between different entities and different parties, the more you grasp over it, and more detail and finer details you get to know about it, so you can give your own perspective to it again and again. From litigation point of view, the more you read to a facts of a case, the more grasp you have over it, and then you will be in an easier position to do research on it. Now, research is something which is very dear to a lawyer, because then he or she can augment his or her points when he or she proposes that before a judge. So to get to that research point of which citation to be used, which not to be used, which judgments to be used, which not to be used, you should read the facts again and again so that different points can come across your mind. So in this particular case, you need to see what was that agreement to sell, when was this signed and formed, whether the old landlady, now I'm stressing on the word old again and again, so I'm giving a big hint here, whether the old landlady was there in a perfect frame of mind when this agreement to sell was formed or not. That's another point you can check on it. This son or daughter who crops up later, whether he or she is in fact a son daughter or not, you can check that up again and again. Whether the tenant has got bona fide clean hands, as we say in court, that the opposite side has not come with clean hands to the court, whether he or she has that clean hands before going to court for specific performance of the agreement to sell, you can check upon that also. These are basic points you can check while reading the facts again and again, and then based on that you can start writing your judgment and start writing the facts accordingly, then the issues which you think are framed, and then the pointers which you think both sides would have made as lawyers from both sides, the plaintiff and defendant, and then you can come to your reasoning and give specific grounds to your reasoning. And if I may say so, a good judge always does his own research work also. He or she does not rely specifically on the judgments proposed by the lawyers, but also does his or her own research also. So you can do your own research on various judgments on suit for specific performance, on the different sections of specific relief act, which you think the different sections would be applicable to this particular fact. And if you think the Transfer Property Act is applicable here, check up that also. Uh, Based on, if you think this is a Delhi case scenario, do check up the Delhi Rent Control Act also. But I think the proposition says that all laws all over India are applicable here. Riddhi, you can correct me if I'm wrong somewhere. So even if you're beyond Delhi also, if there's other part of country which you're assuming this facts have these facts have taken place, then you can apply the local law also. So you can check up, basically my point is that you can check up the different property laws and transfer property act which is applicable in that particular jurisdiction, and then apply it accordingly and give reasons. Giving reasons is very important. Give grounds to your judgment. What is your final conclusion? Whether you think that agreement to sell was there or not, that is up to you, but you have to give reasons either side. If you think it's not there and it's complete forged for fabricated, give grounds for that. If you think indeed there was an agreement to sell between the erstwhile landlady and the tenant, give grounds for that. Give judgment supporting that and give grounds for that. So in a nutshell, if I can say this, go to the facts again and again. Once you start judgment writing, write down those facts in a point-wise manner. Frame the issues which you think are issues relevant to the particular case. After framing those issues, just write down the whatever contentions you think had this been a real case scenario. What would the lawyer for the plaintiff would have proposed to you if you were a judge? What would the lawyer for the defendant would have proposed to you if you were a judge? What judgments you think they would have cited from their side, from the defendant's side, and from the plaintiff's side? And if you can do this and do your own research also and give judgments to whatever final conclusion you come to, and you can back up with your own research also, or you can just cite the judgments of the plaintiff defendant also. That's not a bad thing in itself. But if you can cite your own judgments also, that's well and good. And then come to the reasoning part also with grounds from your side. You can of course in a real life court, these judgments pan out to be 100 page, some pan out to be 50 page, some pan out to be 20-25 page. But I think the competition rules are particular, so just do follow those. And yeah, my best wishes, best of luck. I think that should be good enough without giving any more hints to the proposition.
Yes, sir. Participants, I request you to unmute your mic, or you can post your queries in the chat box in case you want to ask anything from sir. So there's a query from Simi. She's asking, rent control or tenancy act differs as per state discretion. So when we prepare a judgment, do we base it on that particular statute?
Yes, we do. Yes, we do. In fact, based on the jurisdiction, yes, we do. Uh, since this competition has specifically said that laws all over India apply, so you can use your own jurisdiction. If you're in Bombay, Mumbai, use the specific law there. I have little idea about the bylaws of property there in Mumbai. If you're in Delhi, of course, you can assume that this Delhi Rent Control Act can apply, cannot apply. You can go through that. If you see that it's applicable, apply that. If you assume that it's not applicable, don't apply that based on your own assumption. But once you start applying that, then just follow it through till its logical end. So since this is a property matter, so Transfer Property Act would be applicable no matter in which part of India you are. You can see the suit for specific relief act also, since specific suit has been filed for enforcement of an agreement to sell, and then you can correlate that and connect that with relevant property laws of the particular jurisdiction. Whether you're in Delhi or in Bangalore or Mumbai or Calcutta, that is up to you. But yes, relevant local bylaws, real estate bylaws, property bylaws would be applicable to such a scenario, even in this proposition or even in a real life case before court also.
So, her next question is, when we appreciate evidence, does this mean that we can write judgment on assumptions made out from facts in the absence of a plain and a written statement?
Since this is, of course, this is not for the real life cases, but yeah, in this competition, yeah, you can, because there are no real lawyers in front of you doing a chief and cross examination of witnesses, and no evidence affidavit has been filed, and there is no admission denial between the parties. So yeah, you can assume 10,000 things here in this competition, but in real life, this would have been pretty. Without that, it would not have been possible. Uh, so you can assume and make your own pointer. This is the, I think, the beauty of this competition, that you can think from both sides. On the plaintiff side, what would a plaintiff would have been? What would the ground of plaintiff would have taken? You can think what would have been the written statement from the defendant. Would a counterclaim would have been filed by the defendant? You can think that also. I'm again giving another hinter. I'm not sure whether Riddhi appreciates this giving hinters from my side, but you can assume all these things. This is the beauty of such competitions. Then you can assume sometimes issues are being given by both parties also to a court of law, both from the plaintiff side and defendant side. You have the comfort level of making your own issues and then framing them. Uh, you can assume the evidences, what would have been filed on the plaintiff side and defendant side, and what chief examination would have taken place, what cross examination would have taken place, and in fact you can assume that some applications if I can say in Hindi, वो तंग करने वाले applications कई lawyers डालते हैं just to prolong the case, ताकि बस चलते रहे पेशी के पैसे मिलते रहे, if I can say this. So that वो तंग करने वाले application also you can assume under one section 151 this application has been filed by the plaintiff, with this application filed a defendant. If of course within the framework of the rules of the competition, I'm sure I haven't gone through the rules itself, but within the framework of the rules you can have run your imagination as to what the plaintiff would have done, what the defendant would have done, what evidences they would have filed, what would have happened in cross-examination, what would have happened in their chief, and what would have been the final arguments by both the parties. You can make those assumptions and come to your conclusions accordingly.
Okay, so the next question is from Priyank. He's from Mumbai, Maharashtra. So he can use Maharashtra Rent Control Act while writing the judgment.
Yeah, I answered this. Yeah, of course. I mean, you can assume since laws have said that laws all over India are applicable, so you can assume that wherever you are, it has you can make the assumption. But just make sure that once you feel, assuming in Mumbai and this happened in Mumbai, then ensure that all the relevant local bylaws of Mumbai are enforceable there. So don't use Delhi Rent Control Act for Bandra property dispute. Don't use bylaws of Calcutta or Bangalore for a property dispute in Santa Cruz or Worli. So just ensure that you can assume, yeah, that's the beauty of this competition. You make your assumption, but then go on with the logical conclusion till the end. Once you start with it, then don't end up mixing with the laws of some other jurisdiction itself. And of course, Transfer Property Act, CPC, and the Specific Relief Act will always be there.
Okay, sir. Next question is from Vidresh. He's asking, sir, since you have mentioned some very pertinent points, such as presence of witnesses to the instrument and legal competency of the landlady, but sir, in the proposition, there's not even an insinuation to extrapolate on these aspects. In such circumstance, how to proceed?
Yeah, that's why we left that's why we left that to the imagination of the participant, that you can make your own assumption according. Don't always try to read between the lines also. We left that creativity so that you can make your own assumption, because at the end of the day, even if once you are in real court of law, you have to improvise on real life scenarios, what the judge is going to say and how you need to counter that, what the opposite side is going to make pointers, you need to counter that. So we've left this room particularly so you can make an assumption. I have given that hint so that you can assume and make your own imagination. And like I said in my earlier answer also, in this rule, as per the written rules and guidelines of this competition, you can go forward only what the witness would have said, what you can assume. If you are a judge, if a witness has come before you, what you can assume, he has said or she has said, what happened in the cross, what the opposite lawyer said to him or in the cross. Is there some contradiction in the evidence affidavit of a particular witness, and what was extrapolated by the opposite lawyer from that particular witness in the cross examination? So you can make your own assumption and run your imagination accordingly. You can do nothing of that. Make a simple facts, framing of issues, contention from the plaintiff side, contention defendant side, write down two judgments and give grounds also. That is also fine. That is up to the participant. I was giving a hint that if you can run your imagination and do your own creativity and go forward accordingly. That is not a problem.
All right, sir. And there's another question. Since there is a word limit restriction for this competition, it is difficult to paste extracts from the judgments that we refer to. So is it okay if we just name the case on which parties relied on their arguments in respective issues?
Good question. although this would not be a problem in real life, but yeah, in this particular scenario, you can just write those judgment and then just write the para number, and in one line just write what it means in simple language. Of course, anyone who's going through the answer would go through that judgment and the para. Just so if there's a word limit and you think you're not able to express that particular para of that judgment, just write the para number and just in one line say what it means. You can write in simple language. That won't be an issue.
All right, sir. I request the participants, they may unmute themselves and ask their clarifications or queries from sir. So further, may I proceed with the clarification which we received via mail? So if you
Sure,
may
sure.
answer.
Yeah.
The first clarification is whether the city name is Rangil or Rangila.
Wow. Make your own assumption. What can I say?
And the second question, which you already answered, was that which is the Vaibhav Mishra city state that is applicable for the city name. So that is, they can assume themselves. Whether the agreement to sale is registered.
This is a good question. You can see this from the both plaintiff side and defendant side. So we again left this for the creativity of the participants. If you're going for a judgment towards the plaintiff side, you can act accordingly. If you're going from the defendant side, you can act accordingly. I cannot express more to this answer. I think I've answered clearly this one.
Yes.
So it's a particular technical point. If you are writing a judgment on the plaintiff side, defendant side, you can use it either ways.
All right. So next question is date of conveyance deed executed in favor of Gopinath.
Yeah. So
They're asking what is the date of conveyance.
I think date was given there. If it's not given there, see if it's relevant or not.
Sure, sir. And
I'm ready. If I can just clarify this one, if I'm not sure if it's written there, I think it was written there. If it's not written there, then you use your own imagination. You can use it again to your own leverage in itself. What was the date of conveyance deed? Again, this is connected to the previous answer, whether that agreement to sell registration or not. So you can use that to your own advantage, whether you're going for plaintiff side or defendant side.
all right. And the next question is before which court Ms. Rashi has filed suit for specific performance of contract or by which court injunction was granted?
High Court, I think likha hua usme, if I'm not wrong. High Court tha, but I don't see the relevance of that here. I think High Court likha hua hai.
Okay, sir. We'll check it once again.
अगर हाई कोर्ट नहीं भी लिखा कोई कोर्ट से इंजंक्शन मिला है ठीक है
so they can
injunction
assume
मिला
it whether it's high court. All right, sir. And then the next question is to determine the appropriate civil forum due okay, the same question is which city they're asking. And the next question that comes in para 15 of the proposition, when it writes proposition of the said agreement, does it refer to the agreement entered with Gopinath or is it impliedly referring to the agreement to sell entered with Kokila?
which agreement, can you come again please?
In para 15 of the proposition, when it writes performance of the said agreement, does it refer to the agreement entered with Gopinath or is it impliedly referring to the agreement to sell entered with Kokila?
It continues on the previous para regarding which agreement and it refers to that only, so you can without divulging much I can say that only.
Okay, so. And
there's a continuation of language in the I'm getting what they're asking. It's a continuation of the agreement previously is in a flow of language, so they can read that and it's a continuation of that only. That is self-explanatory.
All right, sir. And the next question is, what evidence has been adduced by both the parties?
Judgment ही मैं लिख देता हूँ, इतना पूछ रहे हो तो मैं judgment लिख देता हूँ सर. I mean, make your own assumption. I think I answered this. Assume what would have been the chief. Has there been witnesses? How many witnesses? We leave it to the participants. Who all are the witnesses? We leave it to the participants. What would have been the chief when that would have taken place in a court of law? What would have been the cross-examination if that would have taken place? Or what would have been the questions promulgated by the opposite counsel to the witnesses? since we're living in a COVID time, has this evidence taken place in a video conferencing? Because video conferencing is taking place all over India right now in different courts. So we leave that to the participants. You can make assumptions accordingly. Uh, whether any chief or cross took place and what was the evidence filed. Of course, the evidence filed from the plaintiff side would be different from the evidence filed from the defendant side. But what evidence would have been filed from the plaintiff, what evidence would have filed of the defendant, what would have been the list of witnesses, the witness from the plaintiff side, witnesses from the defendant side would of course differentiated. We leave that open to the participants' imagination and use it and come to the judgment, final conclusion accordingly.
All right, sir. So next question is, the suit filed by Rashi, was it before any civil court of competent jurisdiction or the court of additional rent controller only?
The suit by Rashi was see, the one filed for tenant eviction was of course before the rent control court. The suit for specific performance for the agreement to sell was before a particular civil jurisdictional court.
All right, sir. And the next question is, what is the date and year of the judgment to be pronounced? I guess this will be the same.
Uh, 2020, 2010, 2015.
Yes, sir. And the next question is, what is the annual income of Ms. Rashi Modi? Is any document stating annual income of Ms. Rashi submitted before the court?
How is that even relevant? I fail to understand. Annual income, uska annual income से क्या लेना देना for agreement to sell? कमा रही है अपना पैसा कमा रही है छोड़ो यार. How is that relevant? That is not part of the problem. How much Rashi earns or not earns. If you want to add something which we have not thought about in the problem, as I think I'm assuming what the problem, what this question is about regarding the rental income. That I'm assuming that is the reason for this question. Regarding the rental income, and that's why you're asking the annual income. You can use that if you think there's a point there which you can use in your grounds for final judgment. Use that, make your own assumption. But we have not thought of this annual income part of Rashi or Kopila Ben or the Gopinath, whoever that is.
Okay, sir. And the next question is, what are the prime contents of the counterclaim filed by Gopinath and suit and replication filed by Rashi?
Make your assumption.
So we are done with the clarifications which we received via mail. So
yeah, I mean, I want to answer this, but I cannot because then पूरा judgment ही मैं बना के दे दूंगा तो फिर what's the competition about? So I actually, I mean, with all due respect to those who asked this question, I want to answer, but please try to understand my limitation. I cannot answer these openly. All I can say is that you can assume, make your own assumption within the limitation of the rules of the competition, and whatever the facts is, you can answer, make your grounds accordingly. My straightforward biggest hinter would be that whatever you assume, it is up to you. Use your own imagination, creativity, but just back it up and go to its logical conclusion by judgments or whatever facts you think is there. If there's something between the lines, you have interpreted which we were not able to see. Please go ahead and answer and write down in your judgment. But just ensure you back it up. Back it up with a pointer. Back it up with some logical conclusion. Back it up with a judgment or case law. If you can do that, perfect. Nothing better. So there's a lot of creativity room left for the participants. Use that, use your imagination, improvise, and whatever stand you take, whatever ground you take for jurisdiction or other aspects regarding income, finances, whatever you take, just ensure you back it up and take it to its logical conclusion. Don't mix 2-3 different pointers to make a point. Don't mix 2-3 different pointers to make your own point. Ensure that the person who reads your judgment understands and there's clarification, whoever reads it. If you, भगवान करे सारे participant judge बन जाए एक दिन, जो भी competition participate कर रहे हैं, my best wishes. If you're a judge in a real court of law, you will have to improvise. There will never be a simple, straightforward proposition before you. There will always be some hinters there, here and there. So you will have to improvise. You will have to use your own creativity. So use the creativity, but just ensure you back it up with a case law or facts which you think is there, and take it to its logical conclusion. Don't leave it half-baked or halfway. Just ensure that.
all right, sir. Thank you so much, sir.
Thank you. Thank you.
I again request the participants, if they have any queries or clarifications, they may put before sir. Or you can even unmute your mic. Yeah. So I think we are done with the questions and the clarifications. Anything
Okay.
that you would like to add on or say something like, you know?
Uh, what I can say is that, like I just said earlier, I will not like to reiterate that. Just make it simple, keep it as simple as possible. Just think of it that you're a real life judge and this proposition has come to you. Think, अगर आप judge होते, if I can say it in Hindi, अगर आप judge होते तो आप क्या करते, right? If this proposition was a real life scenario, असली में कोई tenant है, असली में कोई किराएदार है जिसके साथ ये हुआ है, so you need to have that human aspect also. Just don't see it as a problem. Once you become a lawyer and a real life lawyer, this will be you'll be one of the lawyers of a client. लैंडलेडी हो, टेनेंट हो या कोई और हो, आपके क्लाइंट ऐसे होंगे अगर आप लिटिगेशन फील्ड में आओगे तो. सो हैव दैट ह्यूमन एस्पेक्ट आल्सो ऑफ इट. The biggest takeaway from participating in this competition, whether you win something or not, is that you are getting a glimpse of what a judge thinks. Because उस हिसाब से आप अपना दिमाग बना रहे हो. So your mental faculty, once you become a litigation lawyer, will also have that aspect of what the judge would be thinking. So this is the biggest takeaway of participating in this competition. You will understand what a judge would think if such a problem comes before him or her. You can use that whenever you argue on any matter for any court of law anywhere in India, or in fact anywhere. So this is the biggest takeaway. So ensure that just see if you are a judge, if this problem comes before you, how would you think? If you're a lawyer and such a problem, how can you assume the judge would think once you make arguments before that particular judge? How you can make your own assumption that the judge would answer to your particular argument, your proposition, your judgments, or the opposite lawyer would react to any proposition which you make in a court of law. So you can make those assumptions. That is very, very, very important in a court of law while argument, because you have to be on your feet whenever you are there. So if you anticipate what the judge is going to ask, if you anticipate what the opposite lawyer is going to think and going to make proposition, you can counter that accordingly. So this biggest takeaway from this competition is that you can, if you're a judge or not a judge, even if you're a lawyer, you can think of what a judge would think. If you become a judge later onwards, this will help you because you already know how to write judgments and how to think. That clarity in your mind will be there. Facts, issues framed, assuming if there is evidence, chief, cross examination, witnesses, what they say, and final arguments by both the parties, any application filed by both the parties in between on any point of law, and then the reasoning judgments and cases cited by other parties, and then your grounds. And if you can do your own research to get to those grounds, you can go accordingly on that.
So there's one question from Muskan Rawat. She's asking, if suppose my judgment is inclined in favor of the plaintiff, then won't it look biased given in the restriction of the word limit, as it won't be possible to elaborate statements and witnesses for both the defendant and plaintiff?
No, 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 not particularly. No, not at all. Even if you're writing from the plaintiff side, that word limit will not hamper your judgment in itself. You can, of course, give your judgment. Like I said before in the starting, in one of the answers, that you can have a 100-page judgment, you can have a 20-page judgment, you can have 50-page judgment. The grounds are the more specific part. If you see the practical aspect of it, if there's clarification on the reasoning of why you've come to a particular ground, then that should be good enough. And the basic input is that there should be clarification on your reasoning of the grounds. Even if from the plaintiff side, you can give a lengthy and go to witnesses. Don't write three witnesses, write only one witness. That one witness is good enough. Don't write one witness, just assume that no witnesses were filed from the plaintiff side or no witness from the defendant side. So we again leaving that creativity and imagination to the participants. You can assume there were so many witnesses X, Y, Z or ABC from plaintiff side, defendant side, what the chief took place, how the cross exam took place. Or there were no witnesses filed. The defendant did not seem good enough, worthy enough to file any witnesses. The defendant just wanted to rely, without filing evidence, wanted to rely upon his own arguments. Maybe the defendant lawyer thought that his own arguments were good enough. Maybe the plaintiff thought that his own arguments were good enough. Maybe the evidence was not good enough. You can we are leaving that imagination, creativity to the participants themselves. You can assume the evidence was filed, only one witness was filed, or evidence was very crisp and short to the point, and based on that, you can come to the ground. See, a judge, if I can say this, a judge will not only see the one part, just affidavit filed by the plaintiff or defendant. She will always see the conduct of the parties also. A judge has his eyes and he is always open. They will see the conduct of the parties in the court of law also. They will not just see the documentation file, but how the arguments also took place. So you can use the imagination to come to particular point of grounds, whether plaintiff or defendant side. The word limit, if you are just ensure your clarification is there, and there's clarity in what you write down, and someone who reads it understands clearly what you're writing down. And even if there's word limit there, that should not hamper you if you are bringing in a concise form of ground reasoning to your judgment and order. If that is there, then word limit should not hamper whether on what side of judgment you're giving in, whether plaintiff side or defendant side.
All right, sir. We don't have any more questions. Participants are thanking you, sir, for your advice and for clearing out all the
Thank
clarification.
you. I don't know how helpful that was. Of course, if there are any more queries, Riddhi is there. You can email it to her and or to the team at Law Internship. I'll be more than happy to answer those queries.
Yes, sir.
I hope the answers were good enough. I don't know if they were clarification enough, but I hope it helps the participants in participating in this competition and gaining something from this competition itself. Thank you.
Yes, sir. So, concluding this session, on behalf of Team Law Internships, I would like to extend my heartfelt gratitude to Advocate Vaibhav Mishra, sir, for taking out time from his busy schedule and interacting with the young minds. It was truly an enriching session, sir. Thank you again.
Thank you. Thank you.
Thank you, sir.